Okay, good morning, everybody. I'm very happy to chair, and I'm very glad to be invited to chair this panel this morning. Thank you, Lorenzo. You gave me the opportunity to make a short presentation of the French system of the conciliation proceeding. But you give me also the pleasure to meet again some friends and colleagues I had worked with in an ancestral working group on insolvency during many years. My name is Jean-Luc Vallens. I am a judge, former judge, during 40 years, and associate professor in the University of Strasbourg in Paris also during about 12 years. I have been involved in insolvency cases and commercial cases as well. This panel is aimed at preventive semi-formal proceedings, and with Riz Mokal and Stephan Madaus, we have shared this panel in a short description of semi-formal proceedings available and effective in England and in France, and we will have the presentation and the remarks from our German colleague Stephan Madaus about the reason why it can look difficult to enact such proceeding in a legal system where insolvency is very regulated by the law. We should keep in mind the links and the relation between semi-formal proceedings and the other topics we are addressing today, like out-of-court restructuring. We were just talking before the coffee break, but also with duty of managers, because we have to take into consideration the need of relation between the possibility to file for a pre-insolvency proceeding and the duty for directors to file for bankruptcy as soon as their company is already insolvent. There is also a link with the abuse of process, because it can be, how can I express that? A director have a real personal duty to file for bankruptcy in case of insolvency, but in the same time, it's possible, we have sometimes the possibility to see that some directors abuse of their rights and abuse the rights of creditors by filing for bankruptcy only to stop individual lawsuits and to stop any payments. In spite of that, it's possible to abuse also a pre-insolvency proceeding by getting a stay from the lawsuit engaged by creditors in spite of the fact that they are not yet insolvent. So we have to be careful with the links between the advantages of semi-formal proceedings and the risk of abuse from the debtor, but also from the creditors who could push their debtor to file for such a proceeding only to get advantage in preference with other creditors. What is exactly semi-formal proceedings? It's something like proceeding, taking mechanism coming from the formal judicial proceedings and taking some advantage from informal proceeding and out of court. It is just in the middle between out of court and in court proceedings. That's the reason why it's very important to have in the mind the rules that could be enacted in domestic law in the general framework of the proposed directive, because we have to keep in our mind the mechanism proposed by the directive, by the European Commission. I mean here, I'm talking about the stay of individual lawsuits, the duty for the debtor to take some initiative in case of financial difficulties, a certain level of supervision by the courts, but we do not agree, all of us, about the kind of level, about the level of this judicial supervision in front of a demand filed by a debtor. There is another point coming directly from insolvency judicial proceedings. I'm talking about the appointment of a practitioner, because we feel the real need of such an appointment, and we are very reluctant in front of possibility of negotiation without any practitioner, only with the debtor and the shareholders on one side, and the main creditors on the other side. And lastly, of course, negotiation with creditors led by a practitioner under the protection of the law, under the protection of a semi-formal judicial proceedings. During this critical period, the need of involvement of court has to be seen very carefully, because if there is no control, no supervision at all, it creates a risk of abuse in the hand of the debtor or in the hands of the creditors as well. On the other side, too heavy control, too heavy judicial involvement in such proceedings creates other disadvantage and other risk. I'm thinking about the risk of cost, the risk of length of the duration, and the risk of the loss of the value of the company for the company itself and for the creditors, of course. So we have to be very careful with such an involvement, and our opinion is that such an involvement could be enacted in domestic laws on very limited points, as for example the viability test, the stay of individual lawsuit, and approving of agreements negotiated by a practitioner with the relevant creditors of the troubled company. So out of that, probably it's not really necessary to involve more courts in such proceedings. These general view are only here for introducing the real panelists of this morning, Riz Mokal and Stephan Madaus. You are barrister. You are also associate professor in the University of Vallens, and Stephan Madaus is teacher and professor in the university. I have seen the name. Yeah, thank you. First of all, Riz Mokal is going to address and to present the main preventive semi-formal proceedings effective in England for the negotiation of debts, restructuring of the companies, and also the possibility of preparing sale of the company as a going concern. Riz, you have the floor.
Thank you, Jean-Luc. A real privilege to be on this panel. Always a pleasure to work with Stephan, and really a privilege to work with Jean-Luc, who I've seen representing France at the Ancestral Insolvency Working Group for many, many years. Immense admiration from all of the delegates. And when Jean-Luc spoke on behalf of France, every delegation in the room listened and paid attention. He always brought balance and perception and insight to every single intervention, and it was a great loss when he decided not to continue after many, many years. So a real privilege to be back working with you, Jean-Luc.
Thank you, but I have the possibility of to express my opinion in French. That's what's better.
We need to have simultaneous translation here, yeah. So the reason I'm going to take a little bit of time to introduce you to the empirical work we undertook in the UK, not just in England, but in all 4 of the jurisdictions of the UK, is because we think that there are lessons to be learned from the successes, but equally important from the failures, of which there are many, of the restructuring scene in the UK. Those lessons are not going to be capable of being easily transplanted to the EU 27. There are peculiarities of institution and environment which will have to be taken into account in considering whether some of the things which can be learned from the UK experience are capable of teaching something to a particular one of the other EU 27. Nevertheless, it is useful to consider that experience before perhaps rejecting it as irrelevant to those circumstances. So I would ask you, please, to assess the evidence that I will present, drawing on our project's work, in terms of the ability of those insights to be of use elsewhere in the European Union. For obvious reasons, UK may no longer have a direct stake in the game very soon. So we are talking about informal and semi-formal proceedings. So what do we mean by formality? Jean-Luc has introduced this notion to you, and we think that formality has two dimensions. One is impartial oversight, the point at which an impartial referee, to use Lorenzo's term from this morning, intervenes in the process, and the way in which they intervene. Do they have decision-making powers? Do they have only supervisory powers with consequences if they report? Do they have presented a fait accompli because things which matter to creditors and other stakeholders have already occurred? Or are they a referee in the real sense, observing the game and stopping it if they think that a foul is being committed? The second dimension of formality is about the use of collective insolvency law tools, the stay most obviously, but in going in the other direction, the availability of safe harbors in relation to things done or left undone by directors, invoking, this has been mentioned a lot this morning, the duty to file or the wrongful trading type duty to take steps to minimize further losses to creditors if insolvency is no longer avoidable. The degree to which there is a safe harbor for things which are done as part of this semi-formal process, which cannot be challenged in a subsequent proceeding, and the possibility for binding dissenting stakeholders, creditors in particular, but also equity. For us, formality, informality are not a binary division. It's a matter of degree for the reasons that you would all find obvious now, where you place the amount of neutral, paradigmatically court supervision and the degree to which there is use of insolvency law tools. We care about it for the reasons Jean-Luc has mentioned. We care about it because we want parties to be able to make best use of the available tools for the case with which they are concerned and with which, in relation to which they have the best information, not the lawmaker, not the judge, not a third party, but the very stakeholders themselves. And they would have value at stake. They would have skin in the game. So other things equal, they have reasons to get the decision right in a way which is not true, for example, for courts or lawyers or what have you. However, this is subject to ensuring fairness and integrity of the process. And one of the lessons which I think I want to leave you with from the UK experience is it is possible for alleged fairness to trump the integrity and efficiency of the process. Something similar seems to have occurred in significant parts of UK practice, it seems to me. So here is the range of UK proceedings, purely contractual we've been talking about, and I mentioned the RBS experience to you as possibly relevant in other jurisdictions. I'll introduce administrative receivership and prepackaged administrations, schemes of arrangement and company voluntary arrangements we've drawn on a lot in drafting our report, but I won't be talking about today. And then there is the standard administration, which I'll also introduce to you. going to receiverships. In the three proceedings that I want to introduce evidence regarding this morning, receiverships are the least formal. They involve the bank appointing an agent, formally the agent of the debtor company, but in substance owing duties to do what is in the bank's interests, making use of contractual and proprietary rights to take control of the debtor's business, running that business in the interests primarily and in some respects exclusively of the bank, not caring about the interests of creditors other than the bank, and certainly not being concerned about the interests of the debtor as such. The advantages of this system were said to be that the bank had the best knowledge outside of the debtor about the debtor's operations, the quality of the management, the debtor's prospects. The bank would have a significant concentrated stake in the process, and it would have repeat player expertise on which to draw in order to make the decision what to do should the debtor end up in distress. And in particular, the bank would be able to take the decision whether to liquidate the debtor or to allow it another chance of restructuring. The problems were said to be the ones that I've just mentioned. The receiver would have no obligations to anybody, no substantive obligations to anybody other than the appointing bank, and would, by law, have freedom to inflict gratuitous harm, that is, harm which was not justified by corresponding benefits to the appointing bank. That harm would be capable of being inflicted simply because the receiver would have no duties which it might violate in relation to junior creditors and the debtor. So, that is to be contrasted with the system which was introduced in 2002 and which I'll be describing to you in some detail. But in brief, the insolvency practitioner is appointed, again, maybe appointed out of court by the bank, out of court by the debtor company itself, or in court by the bank, the debtor company, or any other creditor, persuading the court to make the order placing the debtor in administration and appointing the insolvency practitioner. The key difference, the people who acted as receivers are the same people who are now acting as administrators. They are insolvency practitioners, mostly accountants. The key difference is twofold. One, the administrator now has duties to uphold the interests of creditors as a group, whereas the receiver did not have that duty. So this comparison between receivership and administration is quite a nice way of testing whether a difference in law makes an economic difference to creditors' outcomes and recoveries and the experience that the debtor business has. And the second important difference is that there is a very hard deadline of 12 months beyond which the administrator loses office, unless the creditors can be persuaded to permit continuation beyond the 12-month period, or the court can be persuaded to order such extension of the administrator's term in office. Again, a nice test of the difference that law can make. There was no such time limit in relation to receiverships. The third process I'll be introducing evidence in relation to is prepackaged administrations. There is no formal statutory treatment of this creature, prepackaged administrations, but in my view, completely wrongly, following pre-2002 law and practice, UK courts permitted the circumvention of the essential machinery of administration, which involved creditor consultation and creditor approval of what the administrator was proposing. That could be circumvented by the administrator being appointed and then, within hours of his appointment, selling the business of the debtor company. And this would happen because the administrator, the insolvency practitioner who was to be appointed, would have been sounded out by the debtors' managers and would have indicated willingness to act as an administrator and to bring about this prepackaged sale of the business. The bank would be paid off in full because the bank would have security, and the security would need to be released for the buyer of the business to get clean title to the business. But all other creditors would characteristically be left in the dark. And this was justified on the basis this was fair in that it was value preserving and businesses would be saved and the time taken would be lower than under standard administration and so on and so forth. So take your opportunistic rationalization and throw it in the mix here. All were thrown into the mix. So that's the third procedure that we are comparing. You can see why this is less formal in our sense. The court and creditors do not get a say ex ante in what the administrator proposes. Instead, they are presented with a fait accompli in relation to something which was brought about at the behest of the debtors' equity-owning managers, keeping the security-holding bank happy, but otherwise leaving the stakeholders in the dark. We won't talk about schemes of arrangement. So here's the database on which we draw in presenting the evidence this morning. We took the cases, all of the cases in administration which were started in 2012. We selected 2012 to give us sufficient time to see how the cases would play out and what would happen to the companies which went through the process. There were just over 2,000 administration proceedings conducted in this period, and we have covered 95% of them, meaning that my able colleague, Alfonso Nosilla, accessed the Companies House database and personally, manually read through the reports filed by the insolvency practitioners in each of these 2019 cases to extract the relevant data. And by comparison, we went to receiverships commenced in 2002, which was the last full year when receiverships operated in the UK. There were 1,008 receiverships in that period, and we cover 47%, just under 50% of these, and a similar process was undertaken. And then these data were put in a database, and my other able colleague, Nigel Balmer, cleaned up the data and undertook mostly regression analyses, but other statistical analyses on these data to compare the way in which the methods, these procedures worked. So these are some of the types of information that we collected. I'll just let you cast your eye over these. But here is what we found in terms of results, starting with a more descriptive slide. Size of the debtor matters in terms of what sort of procedure the debtor undergoes. Smallest debtors, by the way, we divided up all of the debtors by size into one of 5 categories. And the size was measured by using the total outstanding debt as a proxy for size. We use this as opposed to the recorded turnover of the debtor recorded on its own books or some other measure, because this was an objective third-party measure used in other analyses based on the judgment of banks and other third parties about the capacity of the debtor, particularly in terms of its size, to be able to carry debt of a particular level. And this would not be capable of being manipulated in the way that any figures entered into the debtor's own books could be manipulated. So this was why we used these 5 categories. The smallest category is debtors which entered insolvency proceedings with less than £500,000. And the largest category is in excess of debt, overall debt, exceeding £5 million. Judged in this way, pre-packs are most likely in relation to the smallest entities and become less likely for the largest entities. And the larger the entity, the more likely it is to save the going concern of the business. So not much can be done by law on what seem to be brute economic facts, which is the larger the company, the more likely it is to have physical assets and sufficient goodwill in terms of contracts with buyers and sellers to have a chance of being rehabilitated out of distress. The more interesting thing, which turns on the content of the law, is the duration of the proceedings. When you see those comparisons, I would draw your attention in particular to going concern sales from administration and from administrative receivership. Administration, the median, that is 50% of going concern administrations occur in 12 months or less. Now that median is not accidental. 12 months is the statutory limit beyond which administration comes to an end unless positively extended. Administrative receivership, the equivalent figure, was almost 3 times as long. Interestingly, receivership was defended by those defending it on the basis that it was quick and efficient because the receiver only owed duties to the bank, could get in and out very quickly, saved direct costs, but more importantly, saved indirect costs. All of you would be familiar with the indirect costs. The longer the debtor spends undergoing insolvency proceedings, the more destructive for its commercial relationships with suppliers and buyers. So the shorter the period it spends in distress proceedings, the more likely it is to save those direct costs, those indirect costs, to preserve goodwill and relationships. Judged in that way, administrations, even though they require accountability to all of the creditors and to the court, are nevertheless far quicker on average compared to receiverships. And that's true across the board for piecemeal sales and for going concern sales. If you look at the top bullet point, pre-packs, the median is just under 12 months. So pre-pack administrations are now defended on the basis that they are quick. Well, actually, formally, they're not much quicker than full administration. So it seems to me that justification for allowing circumvention of stakeholder accountability, the accountability of the insolvency practitioner leading the process to stakeholders and to the court, drops away. Total realized, you will see that in relation to each of the sizes of company, pre-packs are not noticeably better in returning value, in getting value into the insolvent company's estate. And this remains true across the board. So there seems not to be a loss in the ability of the process to sell off assets to the best buyers, even though the process is accountable to creditors as a group. And that is true in relation both to pre-packs, where stakeholder accountability is circumvented, and receivership. Standard administrations do well. Costs. Pre-packs are not noticeably cheaper because a lot of the costs are incurred before the insolvency practitioner is formally appointed. And if you take those costs into account, which also, after all, are borne by the stakeholders as a group, pre-packs are not noticeably cheaper. They may be in some sizes of debtor, but they are not significantly a reason for justifying the existence of pre-packs. And most interestingly, in terms of returns to creditors, how many pence on the pound creditors get back, administrations of all types outperform receiverships. So the fact that the insolvency practitioner owes duties to creditors as a group seems to have a beneficial effect on outcomes. And pre-packs are outperformed by all other types of administration proceeding as well. Note, in relation to each type of debtor, each size of debtor, so it's not simply that this is a facet of debtor size. A lot has been said about the turkeys, about pre-distress managers and how they might be responsible for problems. This is strongly supported by our results. When sales have occurred, sales of the business have occurred to companies run by the very people who ran the pre-distress debtor company, the outcomes have been noticeably, statistically significantly worse. For one thing, more pre-packs bring about sales to connected purchasers than for unconnected pre-packs. And going concern sale administrations are much less likely where the buyer is a company connected with the pre-distress shareholders and managers. And interestingly, when you look at what happens to the purchaser, after the sale has occurred, where the buyer was effectively the same people who were running the pre-distress companies, the purchaser is likely to enter insolvency proceedings itself far more significantly compared to where the sale was to unconnected parties. And this suggests to us that some of the essential filters for identifying viable distressed businesses and only preserving the going concern in relation to viable businesses are being circumvented when it comes to connected party sales. And once again, connected purchases, the total realized is lower compared to when the sale is to unconnected parties. And this is across the board, true across the board, regardless of the type of procedure. And the costs are higher when the sale is to connected parties. And this suggests to us that the sort of control over wasteful inflation of costs by the insolvency practitioner weaken when it's basically the same people, the pre-distress owners and managers of the company, who are on both sides, who are saying what they're going to pay to the insolvency practitioner and who are also going to be buying the business. And another thing to keep in mind is about returns. I think I mentioned that overall creditor returns are higher when the purchaser is unconnected compared to where the purchaser is connected. And this is 18%, 18 pence on the pound for unconnected purchasers, only 14 for connected ones. And preservation of going concern. Now, one of the really striking findings, which I won't have time to go into, is expertise of the insolvency practitioner really matters. We conducted a set of tests based on dividing up the firm of the insolvency practitioner, taking appointments as administrator or receiver, the top 4 firms, the PricewaterhouseCoopers and Deloitte and so on, then the second tier firm, firms which had up to 100 partners, and then everybody else. And on a significant range of measures in terms of the preservation of going concern, in terms of piecemeal sales, in terms of secured creditor recoveries, the top 4 accountants firms tend to do significantly better in relation to debtors of all sizes. And that's also true of the sales which are conducted by practitioners from top 4 firms compared to others. So expertise really seems to matter. Size here seems to us to be a proxy for expertise, a number of cases that are being dealt with within the 4 corners of that firm. So what are the messages? I think that the key ones for our purposes are self-executing time limits really matter in terms of reducing indirect costs. The fact that the law requires the person running the process to owe duties to creditors as a group really matters. Discouragement of UK-style pre-packs. They have no benefits to on their behalf to justify them, which is not to say that US-style pre-packs are not a good thing. They're a great thing, and we can perhaps discuss that in subsequent discussion. And extra scrutiny of transactions involving connected purchases. And deferred consideration, I didn't mention to you, but where the sale is on the basis that some of the sale price would be paid over the coming months rather than at the point of the sale, that is correlated with significantly worse outcomes. And the final takeaway is that IP expertise really matters, size of the firm being a proxy for that.
Thank you very much, Riz. I suppose many people will have some question to ask you maybe later. I would like to, I have in my mind some question as well, and especially you are talking about pre-packaged administration that works, it seems to work, but I wonder how it's possible for people, affected creditors, affected third party, to challenge all decisions taken within this framework, because you are talking about negotiation and about the transfer of the company as a going concern. But I wonder who is able, who is entitled to challenge with the court such decision, because many rights can be affected by such practices. Even there are good practices, they can create some problem for third party, tax claim and other ones. I would like only to present very shortly the French conciliation proceeding, because it is an example of what works in the French legal system. The first reason of the successful proceeding is that it has been created by practitioners and courts and not by the law. After that, the law has enacted into a commercial code the conciliation proceeding, but first of all, it was a creation of courts and practitioners. It applies to financial, to companies facing to financial difficulties, or when they are already insolvent, but not more than 45 days before their application is filed with the court. It can be opened only on an application filed by the director and not by creditors. That is one point on which we were very concerned by the proposed directive, by giving the right of the proposed directive to the creditors to file for such proceedings, even in the fact that the demand should be present by the creditors with the agreement of the debtor. But in our opinion, such proceeding should remain volunteer, and that's the reason why we do appreciate the last version of the proposed directive, giving member states some flexibility as regarding to this point. The role of the court is very light. The president of the commercial court has only to appoint a conciliator on the demand of the director, of the manager. And one point should be mentioned, underlined: the director is able to propose the name of practitioners who could act as a conciliator. That is a very important point, because it shows the confidence between the debtor and the proposed conciliator. The second point is a limited time of such proceeding. It can be longer than 4 months, or if need be, 5 months, and that creates a real incentive for parties to negotiate and reach an agreement within this time limit. The agreement is lastly approved by the president of the court or by the court itself, depending on procedural question. I don't have time enough to explain them now. The third significant aspect of this proceeding is the possibility granted to the president of the court to stay individual action upon an application filed by the debtor himself for the duration of negotiation, only for the purpose of negotiation. It means it acts like a protection, a shield against individual lawsuits that could be engaged against the debtor, and it is directly inspired by the Chapter 11 of the US Code. Such protection is another efficient tool for the success of such proceedings. The fourth element of this semi-formal proceeding is that the conciliator can build any kind of agreement with the main creditors of the debtor. It can contain any kind of measure, any kind of relief. It can create postponement of debts during a long period, depending on the agreement of the debtor and the creditors, without any time limit. It's possible also to prepare sale of the whole company as a going concern of only a part of the company during this period. If the conciliator prepares a transfer plan as a going concern, so it will be only necessary to open a safeguard proceeding called sauvegarde accélérée, accelerated safeguards, in order to permit the court to approve such a plan containing sale of the whole company to a new owner, a new shareholders. I would like to mention also one of the specificities of this proceeding is confidentiality of negotiation. All parties involved in a conciliation proceeding have to keep the secret on negotiation. There is only one exception. When an agreement is reached, the manager has to disclose this modification of the company to the workers' representative. We have some difficulties with a specific point for listed companies, because this confidentiality can be in opposition with the duty of the manager and the shareholders to express in front of the market the reality of the financial situation. That is a very tricky point, and I'm not sure that the solution is always valid and always effective as regarding to the conflict between this need of confidentiality and the duty to disclose the situation in front of the market. In conclusion, I would like only to give some data about such proceeding. In 2015, the French commercial courts have opened 1,126 conciliation proceedings. We have to see these numbers, that seems very few, in front of the safeguard open during the same year by the commercial courts, 1,500 safeguards, and more judicial rescue proceeding, 18,000, and more winning up proceedings, more than 54,000 proceedings. But these data are not really meaningful, because most of liquidation proceedings concern and apply to very small businesses, companies or individual entrepreneurs. So the conciliation and safeguard proceeding together cover in most of cases, biggest company with a lot of creditors, a lot of debts, turnover, and a lot of workers involved and impacted by the proceedings. So the sole data don't mean a real difference of importance between safeguard and conciliation on one hand, and rescue and liquidation proceedings on the other hand, because the size of the company must be kept in mind when we are looking at such data. I would like also to underline the difficulties to assess and to check the efficiency of semi-formal proceedings, because we know exactly how many proceedings we open, but we don't know exactly how many amicable settlement agreements are workable, and for some years how long they can be viewed as a success. It should be necessary to follow the companies themselves from the very beginning of proceedings up to the period of enactment and application and enforcement of the agreements to know if they work or not. But the general opinion of commercial judges in France is that 2/3 of conciliation proceedings are successful. In my opinion, it's quite difficult to say if it is a good result or not. But we are very pleased to see that most of companies entering into a conciliation proceeding don't go back at any time with the court. So if we don't see them anymore, it means that the conciliation was successful. It's not a statistical approach. It's a feeling. Thank you very much. And now I give the floor to Stephan.
Thank you. After hearing very interesting facts about the way British proceedings work and the French proceedings do, I'm here to give a little bit of a German perspective. And the German perspective is a rather skeptical one towards semi-formal proceedings. We haven't had them so far, and when I enter discussions with German stakeholders, most of them are not really convinced that we need them, at least not to a very big extent, and not at all for all possible cases and companies. But there's at least maybe a growing consent that it might have some sense to do to move in that direction, which we will probably have to do anyway, following the directive, with the name of helping bigger companies and support troubles in bigger companies. But where does that come from, this very skeptical view on the developments that we've seen across Europe for 15 years? So it's not that like we've been asleep, and Christoph already mentioned the migration cases that we've seen. So it led to at least some initiatives in Germany as well, but it never led to any sort of pre-insolvency or semi-formal proceedings. So why is that? Well, the basic idea is that if you look at what the Commission at least proposed, which meant your first slide, if possible, no or very few court involvement, and if possible, no or only in a few cases the involvement of administrators, it means that we have a very unsupervised process, and that is simply right if we look at the first panel, that we basically have an out-of-court process that we don't need to supervise. But from this no supervision argument comes that if you have a playing field where there's no supervision at all, it's just like in a kindergarten. You know, if you have a playing field where there's no supervision at all, at least the kids shouldn't be able to hurt themselves a lot. So you can allow for no supervision as long as you also make sure that no one gets hurt, if possible. So the first initial feeling there is okay. So if we step into the idea of designing such a process, it should be a process with very little infringement of rights, at least no infringement of rights that is not supervised ex post, if not ex ante. So that's where we come from. And then you ask a German lawyer, well, why not allow more? Let's give them room to play, to make experiences. They will learn how to behave correctly once they got hurt. So why not getting into a learning experience? And then there are legal concerns, and basically in Germany, legal concerns are always constitutional concerns. So we always come up with, but that's not allowed under a constitution, so we couldn't implement a directive the way it's meant because we have restrictions under the constitution. And I kind of like to, in 2 minutes, try to follow you through, or bring you through the thinking process that is behind it. And the basic idea is, if you follow the starting point of the directive, which is we need to have something for not yet insolvent businesses, and that is the problem for the Germans. So if you have an insolvent business, which means that there's a collective action problem, that you need to act, and the lawmaker needs to provide tools to protect the interest of creditors as a group, because they are in danger of being infringed because there's not enough for anyone in the group. That's nothing new and nothing addressed or available for companies that are not yet insolvent. So basically, at the current state of their affairs, they're perfectly fine. They're able to pay everyone. So no creditors are yet at the moment being harmed. So now the creditors should be allowed to file for some sort of relief, and get a relief that we only know to be available in insolvency proceeding, which would, for instance, be a stay or a moratorium. Or it would be a coercive restructuring plan being confirmed against the will of a certain creditor. So the question would be, why is that justified? Let's stick with a stay, which is the most prominent example. So why would a stay be justified if you're not insolvent? Why stopping someone's enforcement rights if you're not insolvent? Well, the obvious reason you could do that is if all of those infringed in their rights agree to be stayed. So there's a standstill agreement. That's happening in out-of-court restructuring all the time. So not a problem under the Constitution. Happening in Germany, everything's perfect there. But if someone does not agree, so what can you do then? And then the constitutional law in Germany requires that if you infringe someone's economic rights that have an economic value, you need to give them adequate protection. So adequate protection is key. And unfortunately, if you search for the term adequate protection in the directive, at least in the proposal and in the document that I've seen, it's not in there. What we have is that the stay depends on not being discriminatory against those who are hit by the stay. But from my understanding, not being discriminatory is not the same as giving adequate protection to creditors. So you need to give them full protection. Now, if you have an enforcement right and your debtor is solvent, adequate protection would mean that you get 100% of your claim plus interest for the time that you're not able to enforce your right. So adequate protection is a high barrier for against the background of solvent businesses. So the way to make that cheaper and better available would be to say, okay, adequate protection is fine, but if you need a valuation of how much you can claim as protection, which basically is cash collateral if you have a money claim that is being stayed. So how much is your claim worth? And the debtor is solvent. Okay, at the moment you would probably be able to enforce it for 100%. But let's look ahead. You know, the debtor is not doing this for fun. He's doing it because he smells he has a problem. And if things continue the worst possible way, everyone's insolvent, we have a collective action problem, we have a liquidation, we might even have a piecemeal liquidation, the return rates are low, like 15 to 20%. So let's choose a future point for valuation. When you're in proceedings, when you have a going concern sale in proceedings, or when you have a piecemeal liquidation in insolvency proceedings. And so you try to bring the value down. And this is also something that we might find in the draft directive. So the German concerns are that the draft directive might provide for a system where you can infringe creditors' rights with no adequate protection at all, or if you have adequate protection, then it would be based on a valuation that is not to the current value of claims, but to a possible future value of claims that is assessed with very negative preconditions. So that brings us back to the original point. The German concerns are that this is not constitutional. Valuation should be different. Valuation must be done concerning the right at the moment of infringement. The moment of infringement would be when the company is still fully solvent. So adequate protection should be given to 100% plus interest. But in that case, you know, that the next conclusion would be, and that's the conclusion that I would propose, and that is, I guess, the evolving common opinion in Germany, that a collective stay would not be feasible then. You either have consent of everyone, or you need to pay everyone who's infringed, or at least have protection for everyone who could be infringed, and that's not feasible. So the only feasible solution under the German approach would be to have an individual stay of enforcement actions, provided that someone is actually making trouble, threatening with enforcement, and not being caught by a standstill agreement. So full circle there, we see that the draft directive gives room for solutions that would not be constitutional from a German perspective, but we also see that the draft directive doesn't force Germany to go down that way. It's fully fine under the draft directive to have an individual stay, not a collective stay. So the German Ministry of Justice, as I understood it, is fine with the text as it was there. But then there is legal competition looming. I knew we all look at the Dutch right across the border, or what the French do, or what the Italians might do. So this, of course, doesn't mean that we're a happy island somewhere in Europe. The next question will be that we have an implementation of it based under the German constitutional restraint, and when we might have a very different implementation next door. So that will be the next discussion point there. Thank you very much.
Thank you very much, Stephan. There is a lot of important and relevant remarks in your speech. I do not have the same difficulties with constitutional aspect in France, maybe because we change our constitution from time to time. So it's not really a difficulty for us to imagine that it's possible to move on and to change something if there is any conflict between commercial needs and constitutional aspects. There could be more difficult. It could be more difficult for us to admit the idea very easily that it's possible to stay individual lawsuit for non-insolvent debtors for other reasons. Because of competition law, it's not evident, it's not clear that we should give such an advantage to a travel company because we give it a very preferred, privileged situation in front of other companies acting on the same market, and that could be a problem of equity between companies. I'm sorry, I was not willing to ask any question. No, it's not my role. Maybe it's we have about 10 minutes, maybe a bit more, but I'm afraid we should finish not too late after 1 p.m. So, please.
Hello. Is it on? Yes. Okay. Thank you. I would like to. I'm very distressed. Two things that happened today. First is Michaela and Andre were saying there's not too much that can be done with this text because it's already late. So that brings some of our research down the drain. And the second one is that we've just discovered that so many things breach the German constitution. And if other non-Germans know, is that everyone has to comply with the German constitution in Europe. So we have a big problem here. My point concerns Stephan's remarks, very interesting. And generally, all the things that have been said before, very quickly. First, abuse by debtors, which is a concern by many. Frankly, Riz, we've been doing work in many jurisdictions. Everyone is dead scared of abuse by debtors. That simply doesn't happen. It happens very rarely. People don't use insolvency proceedings and out-of-court proceedings if they want to defraud, because they will eventually come home to roost. Because there are mechanisms. Let's forget about turkeys. It's about chickens that come home to roost here. There are mechanisms to make sure that they misuse the system exposed, they will be penalized for that. So it's like someone who's stolen a car going into the police station. It's just something you don't do. And concerning misbehavior by creditors, not misbehavior, but the problem of infringing the rights of creditors, two minor things. First, let's remember that the stay concerns. First, is brief. Second, it's to tackle the problem of holdouts, and it is for the negotiation period. So this is just to negotiate. With a few exceptions, the damage is quite contained, and the benefit can be quite large. And I believe this is the result of our research, at least from interviews, I don't think there's a concern with the stay, but there is a concern with the stay by some lobbies of the banking sector, which then doesn't really translate into the practice when we talk to, and you see the numbers and you talk to the people who are actually on the ground. Of course, we're talking about 3 months, 6 months of a stay just to negotiate. It's doubtful whether the damage is huge there. And we propose to include an anti-abuse article in the directive which will tackle this and which would allow creditors that have been unduly prejudiced to request a lift of the stay. So we have provided for solutions for this, and perhaps later we will explain about it.
Other question, yeah. Jenny?
Thank you. Jennifer Payne, University of Oxford. So I've got a question for Riz and then a comment, if I may. So Riz, first of all, so I think your hierarchy that you put up as a result of your survey isn't at all surprising. I don't think any UK lawyers would be surprised to find that the hierarchy has the administrative receivership at the bottom, and then pre-pack administration, and then other administrations. But of course, administration is the most formal of the procedures that you put up on the panel. And I just wondered why it was that schemes and CVAs, which are what most people I think would think of about semi-formal restructuring in the UK, that wasn't part of your survey, because that obviously would have changed the outcomes. And in particular, if you think about schemes, for example, there's no time limit issue that you'd want to put in place. You don't have an administrator or an IP practitioner in the mix there. So I just wondered why it was that you'd structured the survey as you had. Maybe you could say something about that. The comment, it comes back to this question about the possibility of abuse and the role of the court. And of course, in the panel 1 this morning, when we're talking about purely contractual restructurings, we don't need there to be a role for the court there. Contractual restructurings are in the hands of the parties, so you only bind the parties who contract, and you're only bound if you do agree to the change of conditions. So there's no need for the court to have a role or oversight. You can leave it to contract law for the parties to protect themselves, particularly where, as we have in the UK, the parties to a contractual restructuring are the financial creditors. They're well able to protect themselves. So you don't need court oversight at that point in time. But of course, once you move into semi-formal restructuring, where you have stays, where you have the ability for the restructuring to be imposed on creditors who are not consenting, so you're interfering with contractual rights, then you do need court oversight, it seems to me. And that court oversight could be built into the process, as we see in the English scheme, or it could be a more implicit part of the process where creditors can appeal to court if they're unhappy. I mean, I think the idea that's being put forward at the moment in the directive is that that's going to be very light touch, that it's only in relation to the stay or in relation to the cram down that creditors would have those sorts of rights. I wonder whether actually we don't need to think more broadly than that, because there are some very fundamental mechanisms of protection for creditors, such as information rights, such as the organisation of creditors into classes, which are also pretty fundamental and which also might well need to be taken into account in terms of the role and the oversight of the court in this process, in order to ensure actually that abuse doesn't happen in the organisation and the process of the restructuring, as well as at these pinch points, which are obviously raising very dramatic and particular concerns for creditors. Thank you.
Jenny, thank you. Just to take those points very quickly, scheme data are not publicly available, so it's not easy to do a comparison on quantitative bases, which would be representative. So that's the reason why we did not draw on schemes in this part of the study, but the report that you've seen draws extensively on scheme jurisprudence and CVA jurisprudence. CVAs are, good work exists on CVAs, and they are mostly a very small company phenomenon, so we didn't think that it would be worthwhile undertaking fresh research on that. I don't think that that you are representative of opinion within the UK as to it being nothing surprising that pre-packs and administrative receiverships are at the bottom. That's certainly not the impression that UK practitioners and academics would give you. There are strong proponents of pre-packs, completely wrongly, in view of this largest data set which has ever been compiled. All of the evidence suggests there's utterly no justification for pre-packs. Worryingly, some European colleagues have talked about learning from UK pre-packs, so I really want to strike a note of warning that would be a disastrous thing to do. That would be exporting the worst of our processes rather than the best. And we still have receivership proponents still talking about the streamlined ability of secured creditors to go in and do their thing, and that's all hunky-dory. So it simply isn't the case that in the UK, the debate is settled. It's wrongly not settled, in my view, but it's not settled. And that's particularly worrying because the UK is often held up as a model from which lessons could be learned. I think we should be warning our European friends against learning the wrong lessons.
May I just quickly intervene there? Just a word from the German experience there. In Germany, 98% of all cases, and I guess close to 100% of all rescued businesses in insolvency, and we only have insolvency, are saved by a going concern sale, if they are saved. We only have a planned percentage of like 2 to 3%. So what we do is selling. And why it works so well, and we always cite the Doing Business report, but apart from that, why it's doing well is because it's quick. We have some sort of a pre-pack, but we prepare in the interim proceedings. So once you file, there are interim proceedings, so that you have a preliminary administrator, but you also have a preliminary creditors committee. So you have a lot more of transparency than you have in UK proceedings, as I understand them. And you sell on the first day of open proceedings. So you have some sort of the same effects of a pre-pack. You need to open to have all the positive effects of a pre-pack sale. But the decision to do the sale is then up to the creditors committee, or if it's an insider deal, even to the creditors assembly, so the general meeting of creditors. So there are broader safeguards there concerning the price and the sales process and other options and other sales options. And a final note is we do not see that many insider deals, which might be due to the requirement of having a creditors assembly, so the general meeting approving it. So it's not the preferred option to go. And I was wondering when I saw the numbers that insider deals might only be an option for those businesses who do not have an outside bidder. So it might be an indicator for a rather weak, maybe not viable business. So to me, not a surprise that these kind of deals have a lower price than an outsider deal, and then that they fail more often. But that's just as idea.
Thank you. Two more questions, maybe a third one, but it will depend on the length of the questions, you know. Reinhard?
Yeah, thank you very much. As Jean-Luc explained, French law has been built on years of experience by practitioners and by courts. Now, what is the lessons to be learned, if lessons could be learned from France? If you look at conciliation, in conciliation, the automatic stay was available as an option for years. It was not used. It was never used. It was counterproductive and abrogated. Because pre-insolvency, you have to pay your debts. You have to pay your suppliers, you have to pay your salaries, you have to pay all the business contracts, because otherwise the business is dead and you should go into real insolvency. So in my view, the idea of having a general stay is a false good idea. It is just, you have to file for normal Chapter 11 type safeguard formal insolvency proceedings if you need a general protection against all your suppliers who are asking payment and you're not able to pay. So it is, in my view, ridiculous to promote the idea of a general stay in pre-insolvency proceedings. And I fully agree with Stephan, not for constitutional reasons. As Jean-Luc said, we can change this very quickly at Constitution in France. But it is common sense that requires that the general stay is not a good idea. But the individual stay is a good idea. It is needed because you have some very aggressive hedge funds in this world. I don't name them, but they could blow up the whole process. They blackmail the debtor. And these people has to be calm down for the duration of the negotiation, which may be 2 or 3 or 4 months, and it doesn't hurt anybody. It just neutralizes somebody who takes advantage, undue advantage, and I fully agree once again with Stephan, there is a really good reason to do this. And so the pre-insolvency proceedings, in my view, has to focus on individual suspension mechanism and the possibility then to do only a cram down if you are likely to present to a court an agreement that is likely to have the majority. And basically, the scheme of arrangement, lessons to be learned from England, is the scheme of arrangement. There's no general stay. It's a mechanism of cram down, and that's needed because you have to cram down minority creditors efficiently and in a very, very short period of time. So what has to be supervised is the formation of the classes and the protection of third-party minority creditors in cram down. Thank you.
Thank you for your remarks. It's not really a question, but it's a very important remark. Nico?
Yeah, Riz, I have to disclose that I'm one of those people who have been very vocal in trying to import your UK-style prepack in the Netherlands, so that by way of remark. Now, genetically, I'm very inclined to agree with you, Riz, with the results that you've presented. Yet, somehow, I'm still hesitant to be fully persuaded by the conclusions that you draw from your empirical research without actually having analyzed the underlying data. And because it seems to me a little bit that it might be difficult to actually use this data to compare processes as such. My impression is that it could be the case that these results, the different results for the different processes, actually say more about the nature of the cases in which you use each process than the process itself. And that nature can be very different. Was it asset rich, asset poor? Was it in a service industry or normal industry? Was there new finance available? Was new finance not available? And so I would think that to draw sensible conclusions from this, from any empirical observation, you would have to check, if I have this case, what is the result if I use this process, and what have been the result if I would have used any other process? So that's just one remark I have about the research. That's one, and then I have a short question, and the question is this: an important observation in this report I fully share, and that observation is, it is important to facilitate business sales. In my view, business sales are actually much more important than restructuring. Absolutely, I think that is a very important point. Now, everyone in this room here, including you, Riz, and myself, will agree that we need to think very hard, what is the best way of facilitating those business sales, of maximizing value, of allocating resources in the most efficient way, which is an important macroeconomic function of insolvency law, and dealing with the challenges that are inherent to distress. And those are multiple. So my question to you is, how would that process ideally look like?
Before giving you the floor, I would suggest to have a last question, and after you will conclude. Yeah, yes, of course. Please.
Thank you. It's on, okay. Thank you. My name is Matti Engelberg. I'm coming from Hannes Snellman, Helsinki, looking this preventive restructuring from Nordic angle. Question to the esteemed panelists. The preventive restructuring or the restructuring directive is based on the grounds that the instrument framework is available when there is a likelihood of insolvency. If you compare this to UK scheme of arrangement, which is beautiful product according my judgment, that only requires that there is a need of compromise or arrangement with the company. And question to the panelist: do you see this requirement in in the draft directive as a needed test for the courts to apply.
Thank you. The last word for Riz.
Taking that point first, we think that it's a very bad idea for a variety of negative and positive incentive reasons for there to be a requirement to demonstrate insolvency. You pointed out quite correctly and rightly about the scheme of arrangement not requiring any demonstration of insolvency. The administration process in the UK, where the administrator is appointed by the company itself or by the bank, does not require any demonstration of insolvency. Chapter 11 in the US does not require any demonstration of insolvency. We have very thriving, flourishing restructuring regimes on both sides of the pond, which dispense with the requirement for demonstrating insolvency. We really urge the Commission to take a look at this. There are all sorts of atavistic fears about allowing insolvency proceedings when there is no insolvency. It's nonsense. No debtor is going to, for reasons that Ignacio mentioned, no debtor is going to start an insolvency proceeding, absolutely crushing its reputation with its stakeholders and counterparts, absolutely crushing the prospects of continuing in business on the basis of a temporary advantage of a stay or something like that, unless it really needed to make use of the insolvency proceeding. So you can't have it both ways. You can't say we want early resort to these pre-structuring mechanisms and then say at the same time, but you have to be insolvent or likely to be insolvent. Well, you may be insolvent or likely to be insolvent, but you need to be able to use the mechanism before insolvency is demonstrable, and trust the market, which is not some magic creature, but it's the people who are doing business with you. They will refuse to do business or refuse to do business on favorable terms if you've invoked an insolvency proceeding or a pre-insolvency proceeding. So we think you should dispense with the requirement to demonstrate insolvency. Nico, underlying data, this database was created using European taxpayer funds. So once we have put out the report in its final form, we will publish the database on the Co.Di.Re website. So you and all other colleagues are fully able to look at the underlying data and reconduct the analyses. So we will be making this available. In terms of comparability, you're absolutely right. We have done the traditional thing of controlling for a variety of factors, including the industry, the region in which the debtor was located, the amount of secured debt it had, the types of firm from which the insolvency practitioner was drawn, etc., 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 and of course size, which is the big thing. We have sought to control for all of those factors, and the results that I'm suggesting to you, which I'm showing you, are the results after controlling for all of those factors. Of course, it may be that there is something we haven't controlled for. Well, point this out, and we will control for that as well. But we have control for everything that we could think of. So there isn't any obvious factor which might be underlying the differences. We think that we've captured something essential about the process, which is you get rid of stakeholder accountability, you introduce abuse, and you introduce low-quality outcomes.
Lorenzo.
Yeah, Nico's question. Can we try to answer Nico's question on what would a system designed to quickly sell the business as going concern should be designed? I think this is a fundamental question. So what you are suggesting, let's not copy the pre-pack. Is there any alternative, or simply we should try other avenues?
So the three things which are absolutely essential in some combination are exposure to the market, the input of creditor decision-making on what should happen, and supervision of the court. These three are going to be overlapping, but also substitutes to each other. And exactly what proportion of each of those mechanisms should play a part will differ from circumstance to circumstance. But there is no other magic fourth possibility. There's exposure to the market of the business, accountability to the parties whose money is at stake, and then the referee, the neutral arbiter, the judge having a say. That's it. So combine in the right proportions, and you get the right procedure.
Thank you very much. Thank you very much to everybody, to the panelists, and thank you for having answered to so very tricky questions and difficult ones. Bon appétit à tous.
If I may, we should have a quick lunch, take something, and then go back, because we have to adapt our schedule to Michaela, who very kindly adapted hers to us, which is important. So.